Hello and welcome to Smart Contracts, Digital Goods, and the Adaptability of Law to Web 3.0. So, preamble, the Law Commission in its 2021 report to the government on smart contracts issued the following statement. The flexibility of our common law means that the jurisdiction of England and Wales provides an ideal platform for businesses and innovation without the need for statutory law reform. Now, LC 401 refers to the smart contract summary, CP 563 refers to this report to the advice to the government. So this presentation will achieve the following aims. Critical analysis of the adaptability of the common law framework of England and Wales, English law, to innovative, evolving means of digital commerce characterized by Web 3.0 technology. It will ultimately answer, is the common law framework of England and Wales sufficiently adaptable to facilitate this legal commercial innovation without statutory reform? So what is Web 3.0? Well, Web 3.0 is a catch-all term for a new iteration of technologies based upon blockchain and other developing distributed ledger technologies, DLTs. These include smart contracts and crypto assets, as well as other intangible blockchain-based digital goods. The adaptability of various aspects of common and statutory law to these commercial instruments will be the focus of this presentation. So what is a smart legal contract? Well, a smart legal contract, or smart contract, is a digitally based, legally binding contract in which some or all of the obligations are recorded, rendered, and performed automatically by an automated computer program on distributed ledger technology. Now, the defining characteristic of smart contracts is that they can automatically render and execute contractual terms. So terms and performance of the contract can be rendered completely automatically without any human involvement. But for the purpose of this presentation, smart contracts will refer solely to the DLT-based as opposed to algorithmic smart contracts. Smart contracts were first coined by Nick Szabo in Smart Contracts, Building Blocks for Digital Markets, 1996. Nick Szabo analogized the dawn of smart contracts to the use of vending machines over human vendors, for example. A vending machine carries out a contractual agreement semi-automatically for the purposes of commerce. However, in this case, a smart contract would carry out a contractual agreement fully automatically, potentially. So the Law Commission identified three types of smart contract in the report. Firstly, a natural language contract in which few of the terms are coded. So in this case, the code itself is just a tool employed by the parties to perform the contained obligations within the contract. Secondly is a hybrid contract in which some or all of the terms are coded, and these types of contract can be considered on a spectrum. On one end, almost all the terms are defined and executed by code, and on the other, only a select few are defined and executed by code. Thirdly, the most challenging type of contract to interpretation is a contract in which all terms are rendered, defined, and executed by code. There is virtually no human interaction with the terms of the contract here. There's virtually no human oversight in giving effect to these terms either. So, do smart contracts require statutory law reform? The Law Commission held that statutory reform is not necessary to validate smart contracts as legal instruments and facilitate their commercial use. Common law principles and the development of interpretive guidelines would suffice for this. So to assess the veracity of this position, the following slides will outline the challenges presented in commercial law by smart contracts in two parts. Firstly, coded terms and challenges to contract law theory. This will mainly cover the issues of interpretation to coded language that is not natural language, quote unquote. And secondly, we will be assessing the digital context in which smart contracts will be used. So this will be digital goods, Web 3.0, blockchain assets that are intangible, and the challenges to the concept of possession in law. How does these goods and their unpossessibility, quote unquote, expose the unsuitability of terms such as goods and property under the Sale of Goods Act in the modern commercial world? The following section will examine the first of these two challenges, coded terms and challenges to contract law theory. So, smart contracts present issues to the interpretation of commercial contracts due to their coded terms, because they are containing non-natural language, and thus interpretation principles that give primacy to natural language and contract language are largely redundant. However, the Law Commission has argued that the commercial law principles, common law principles of contract formation and interpretation remain, in theory, entirely applicable to smart contracts, and you can find that in the quoted report below. Firstly, contractual interpretation is incredibly important to the sale of goods. It allows the courts to ascertain and give effect to the intention of the parties. This is based on the overriding principle of good faith and freedom of contract in English law. The intention of parties is conventionally ascertained from an interpretation of the ordinary language of the contractual terms, and this is assisted by contextual factors such as industry norms and the trading history between the parties involved. And we get this from Arnold v. Britton, in which Lord Nuremberg set out the rules for ascertaining intention, which is giving primacy to the natural and ordinary meaning of clauses and the relevant provisions of the agreement, rather than secondary contextual factors that were prior mentioned. So in the absence of any of these, in the absence of natural language to contain these, to ascertain the intention from, statutory rules of interpretation, such as those contained in the Section 18 Sale of Goods Act, guide the process of ascertaining intention of the parties, where it cannot be ascertained from the terms of the agreement itself. So to illustrate the importance of intention in the sale of goods, we will use the following legal mechanisms in commercial law to illustrate its importance. For example, evidence of intention is required when a contract of sale is formed. This is perhaps the most important part of where intention takes place, because it requires intention to create legal relations, and certain terms and obligations implied into contracts by statutes such as the Sale of Goods Act are only enforceable in the absence of a contrary intention to imply them. Secondly, property can only pass when intended to pass, under Section 17 Sale of Goods Act, and risk can only pass when property does, and property passes as intended, under Section 21 of the Sale of Goods Act. Possession is passed only when intended to, because it requires the seller's consent to depose possession in the goods to the buyer. So these rights cannot pass without intention, and this is evidenced by the common law rule Nemo Dat, that being a buyer cannot in good faith acquire property rights if these have not been intended to be passed to them. So, how do coded terms challenge attestation of intention? The attestation of intention is of fundamental importance to facilitating the sale of goods at law at every stage, from formation of the contract to the transferring of property rights from buyer to seller or business to consumer. Smart contracts are formed entirely of coded terms challenge the sale of goods law because common law principles ascertaining intention typically rely upon interpretation of ordinary meaning of natural language, as we prior mentioned Arnold v. Britton. So if the law is to facilitate the use of smart contracts, coded terms must either be A, susceptible to existing common law principles of contractual interpretation, or the common law must be able to adapt to them by developing these common law principles. Alternatively, they must be subject to statutory guidance, ensuring that coded terms are interpretable or implemented in an interpretable manner. So, for example, statute could make law that coded terms must be susceptible to conventional principles of interpretation, such as through code markers providing natural language to give the intention of these coded terms, or natural language prefaces to each coded term to provide an idea of the intended effect, or the intention of the parties at the time. Alternatively, coded terms alone cannot exclusively form a contract at law. A smart contract must contain a hybrid of coded natural terms, or there must be a clause to determine if natural language or coded terms would have primacy in interpretation. That final point was brought up by Catherine Phillips in Law Commission paper, Law Commission response to the call for evidence at page 60. She suggests that as good practice, all parties should have some kind of natural language preface or clause to indicate which one will have primacy in the interpretation. Coded terms, coded language, or natural language. Moving on, we have the following arguments illustrate that the common law principles of interpretation are not applicable to coded terms. Firstly, code has no meaning. It can only give effect to terms. Code in itself is only interpretable by the surrounding context. In the absence of this, it must be uninterpretable. Thus, principles of contractual interpretation, conventional principles, are redundant vis-a-vis coded terms. Because a machine does not take such steps to interpret the intention of the parties, the code is solely defined by itself and its effects, and it cannot be susceptible to conventional interpretation. So is statutory reform therefore required to ensure that coded terms are interpretable? Well, not necessarily. Consider the following arguments. Coded terms themselves may be uninterpretable. However, surrounding context, extrinsic facts, etc. can all provide sufficient grounds for conventional contractual interpretation. Allen and Overy, for example, argue that where there is an intention to create legal relations, this is easily discernible from the facts, and equally, where there is not one, we would expect parties to make that clear. The Law Commission similarly argues that the analysis required is one of ascertaining intention of parties by conventional means from admissible materials. So they argued that a greater range of admissible materials should be made admissible into courts as a means of interpreting the intention of the parties. Now, the counterpoint to this, however, is, as listed in the final bullet point here, common law principles currently don't permit such a holistic approach, and this wide range of materials would not currently be admissible as per common law principles. So with that in mind, reform to principles interpretation, if necessary, and it may be, as seen above, these can be achieved in the common law or by the development of customary practices. So, for example, we have the Law Commission's proposed reasonable coda test as one such example of how they could develop this, and that is based on the principles of reasonableness, as is the test in the Unfair Contract Terms Act, Section 11, for example. They've also included recommended guidelines for interpretation to take into context the automated nature and non-natural language of coded terms. And again, Catherine Phillips brings up her argument here that smart contracts should contain a clause as to which coded or natural language is given primacy in the interpretation of smart contracts. So I've also put in this UCP and EUCP as examples of innovation in customary practice. And the UCP contains a number of standard terms relating to letters of credit, for example, and that is one such evidence of how reform can occur without statutory law reform. And the EUCP supplements this in the digital world by bringing in how letters of credit interact with digital contracts, for example. All these examples serve to show that the relevant principles of interpretation, if necessary, can be developed and achieved in the common law by the development of customary practice or common law principles. Statutory reform is not necessarily required, and in conclusion, therefore, the prior arguments serve to illustrate that a principal development of existing common law principles of interpretation will suffice to make coded terms amenable for the facilitation of sale of goods via smart contracts. The example of contractual interpretation and its flexibility illustrates how the common law system of England and Wales can be flexible to legal and commercial innovation. However, the adaptability of the common law in this particular area does not prove the initial statement true in the broad terms it was asserted in. So the initial statement, to recap, was that the flexibility of our common law provides an ideal platform without the need for business and innovation, without the need for statutory law reform. Now, the veracity of this statement can be assessed through an examination of the status of digital assets as goods at law in relation to the Sale of Goods Act and the problems that arise under this. So, defining digital assets and the future of commerce in Web 3.0. For the purposes of the presentation, all digital assets referred to herein are defined as wholly digital and intangible assets. Notably, for all intents and purposes, market participants already view these digital assets as property capable of possession and for sale just as much as goods are. This has been noted by the Law Commission in Digital Assets, ensuring the law recognizes and protects digital assets in a digitized world. You can also see the software incubator case in which the judge recognized this fact. Now, this is notably problematic as the law does not recognize that intangible assets are capable of possession at law. And because they cannot be possessed, they cannot be goods as defined currently by the Sale of Goods Act 1979. Without recognition of digital assets as one of goods, parties to the sale of digital assets can go unprotected by implied terms and protected provisions under statutes such as the Sale of Goods Act, the Supply of Goods and Services Act, and the Consumer Rights Act. So if the trade of these digital assets is not considered one of goods, parties will go unprotected by implied terms and protected provisions. So that brings into the question, is the definition of goods under the Sale of Goods Act still appropriate with a view to this? Well, how are goods defined under the Sale of Goods Act? They are defined in relatively broad terms. Goods includes all personal chattels other than things in action. Now, in common law, personal property is considered either a thing capable of possession, known as a thing in possession, and if not, it is a thing in action and thus excluded from the definition of goods under Section 61 Sale of Goods Act. So traditionally, it's been held that digital assets were not capable of being possessed at law, thus they were not capable of being goods under the Sale of Goods Act. The relevant academic opinion here is Joseph W. Bingham, and he says that the word property is used to denote physical objects of property rights. So, for example, a car is a tangible object with respect to which property rights can exist. Now, this was supported by St. Albans City, for example, in which it was held that if there are no physical objects, there are no property rights. This is changing, however, as the law has recognized that intangible digital assets can be considered property and owned as such, as a shows in action. This means they fall into neither category traditionally understood to be possession. This was held by AA v. Persons Unknown, RE Bitcoin, in which it was held that cryptocurrencies such as Bitcoin could fall into a third category of possession, and this isn't currently clarified at law. This raises several questions, such as what type of crypto assets can have actionable rights and property under this third category, and the unclear interaction of crypto keys, for example, which count as a physical asset, do they count as a thing in possession for the purposes of the Sale of Goods Act? So following AA v. Persons Unknown RE Bitcoin, we have the following conclusions, summed up by Jackie Heathfield and Rebecca James. Crypto assets are not real property, nor may they be physically possessed. They are only considered property to the extent that they are shows as an action. That being that crypto assets represent a property right that can only be enforced against third parties. They themselves do not have a property right that is freestanding as would a conventional good that can be quote unquote possessed. So they do technically fall within the definition of property. Now, this was also examined by the UK Jurisdiction Task Force and the Law Tech Delivery Panel, in which they proposed that crypto assets could indeed fulfill Lord Wilberforce's 5 criteria of property in National Provincial Bank v. Ainsworth, as well as the undefined, relatively vague definition of property in law generally, which is taken to include certainty, exclusivity, control, and assignability. Now, these characteristics are all characteristic of crypto assets, for example, so they could be considered property at law. So, in conclusion, the current state of law would seem to indicate that, firstly, crypto assets and intangible assets are not possessible per se, and therefore they are not goods under the Sale of Goods Act. As things that are not in possession, their transfer is not justiciable in commercial law. The sale of goods, rights and property cannot be conveyed from buyer to seller in the transfer of these items. However, these goods can still enforce property rights against third parties as a chosen action. They do not actually have rights to possession in themselves, as they cannot be possessed, and these rights cannot be transferred to third parties. Despite falling outside of the scope of commercial law, therefore, personal property law can provide digital asset owners with some limited enforceable rights against third parties. This does not resolve the overarching issues, however. Enforceable rights in property law are not sufficient to protect private parties acting as commercial parties in the trade of commercial goods. If these private parties are transferring digital goods as digital assets as though they were quote-unquote goods, they should be subject to the same implied minimal guarantees by statutory law, implied terms, and protective provisions, for example. So, that said, crypto assets have no conveyable freestanding property rights as an interest in ownership. Thus, even if they were to be considered goods under the Sale of Goods Act, they could not be a valid transfer at sale because property rights would not transfer between parties. So, without sufficient protection for the sale of these revolutionary goods, the framework of England and Wales cannot be said to be ideal for business and innovation. Reform is clearly required to bring intangible and digital crypto assets into the jurisdiction of commercial law, providing legal commercial certainty to parties trading them, and this position is reflected by the Law Commission in their currently developing paper on digital assets, in which they acknowledge that the transfer of digital assets without commercial law protections, as though they were the sale of goods, has created inconsistent protection for parties to trade, and this can affect both consumer and commercial parties. So, amendment could be implemented through statutory reform, such as the Sale of Good Amendment Act 1995, and that, for example, included an undivided share in goods under the Sale of Goods Act definition of goods, for example. That was an intangible form of good that is now a form of good under the Sale of Goods Act, section 61(1). So in conclusion, this presentation has concluded that certain elements of the common law framework of England and Wales are sufficiently adaptable to facilitate legal commercial innovation characteristic of Web 3.0, such as smart contracts and coded terms. These can be subject to some common law development, but generally they are amenable at common law. However, the commercial law framework of England and Wales requires clear statutory reform to become an ideal platform for business and innovation. The reason for this is because property rights currently do not exist in digital assets that are being traded as goods by market participants, proving that the notions of property and goods under the Sale of Goods Act are far too restrictive and inadaptable to facilitate the use of evolving elements of modern digital commerce, such as intangible digital goods and crypto assets. In order to better protect these parties and truly become an ideal platform for business and innovation, parties to these kind of trades need to be recognized as the commercial parties that they are. This has been Smart Contracts, Digital Goods, and the Adaptability of Law to Web 3.0 Technology. Thank you very much for watching.